Estate planning is essentially the process of anticipating death and prearranging the disposal of an estate. On Wednesday, March 16, 2011, Mayberry Investments had an interesting investor forum which focused on estate planning strategies. Attorneys at law Georgette Wilshire and Denise Henry James, one of the island's leading estate planning attorneys, made eye-opening presentations on the subject. A will is an integral part of estate planning, as Georgette Wilshire pointed out.
The will must be signed or acknowledged by the testator in the presence of two witnesses who must be present at the same time, and the witnesses must thereafter sign in the presence of the testator. And it is also important, after all of this, that you date the will. Otherwise, your attorney will have to draft additional documentation explaining why the will was not dated, and have the witnesses sign affidavits to say, well, we were present at this time, and it adds to a further delay. So it might seem simple, but just ensure that the will is dated. And it's also, in case two wills are found, it helps to find out which will is the later will, because in drafting your will, there's usually a clause to say you revoke all previous wills. So the date on the will help to identify which is the last and the valid will.
How does one go about drafting a will?
Things to note when you're drafting your will. Neither a witness or the spouse of the witness can take a gift under the will. The gift will be void even though the rest of the will be valid. And that gift to the witness will be void and it would fall to the residuary clause. The executors can be beneficiaries under the will. A will has no effect on property that is jointly owned. For example, if you and your spouse own property as joint tenants, you cannot, and you die, you cannot, in effect, draft a clause just to say that I will it to my children. You would have to say, in the event that my wife does not survive me, then I give the gift to someone else. Any alterations or amendments made to the will must be initialed by the testator.
Leading estate planning attorney Denise Henry James emphasized why estate planning is vital.
And from my perspective, there are really two main reasons. I want to try and shelter the estate against the large cash burden that all estates are going to be facing. Georgette had mentioned them, and I'm going to go through them in more detail with you. And secondly, I want to eliminate any complications from the client's affairs that they may have created in their estate, even though unwillingly on their part. So these are the two main things that we really want to focus on. We can't avoid the taxes. What we want to do is try and minimize these taxes that Georgette has mentioned, and I'm going to take you through them. And what you would have learned from this evening's forum is that there's a lot of complications that you could have created. For instance, Georgette kept telling you the importance of having your will. That's the first thing you really need to do, because if you have a will, not only did you take the time to determine who your beneficiaries are, but you have chosen the road of the one that is going to be the most effective, in that your estate can be wrapped up in under 12 months.
There are taxes to be paid, and one has to recognize what these are and probably plan ahead.
So let us have a look at what are these taxes that we're talking about. There are four main taxes, and what I'm going to do is identify them for you, but go through them with you in much more detail. The first one, which Georgette had mentioned to you, is transfer tax. As far as the government is concerned, once you die, you must have assets that you own that have to be what? Transferred to your loved ones. And since they have to be transferred to your loved ones, hence we came up with the transfer tax. So under our Transfer Tax Act, they identified certain assets that you own that are going to be levied with a tax and that you have to pay it when you die. Now, under the Transfer Tax Act, they identified certain assets. Unfortunately for us, they chose our most expensive. So they start out by telling you any real estate that you own in Jamaica, if you're a Jamaican by birth, and overseas, you're going to pay a transfer tax on it. They then chose your shares in any company that you own. So whether the shares is in your own private company that you found, or if what? You have invested on the stock exchange, then you're going to be paying transfer tax on shares. And not only shares in Jamaica, but all the shares that you own overseas. Third one, debentures. It's not something that a lot of us invest in, But once you own debentures, you're going to have to pay the transfer tax on it. So having identified your 3 transfer taxable assets under the law, now we had to look at, well, what tax are they going to levy? Now we have gone through a number of changes in relation to this. I want to take you through it because the act was never made retroactive. So all the time you have to apply it to when the person died and when their estate is being administered. If you died before June 2005, the transfer tax was 15%. If you died after June 2005, the tax was reduced to 7.5%. So good things were happening and we were coming down. It went on again and said once we died after May 2008, they took it down to 6%. Audley then came along and says he wants to reduce it further because it was something that we were lobbying for. And once you died after January 2009, it went down to 5%. If you die after August 2009, he took it down to 4%. So when Georgette says to you, we've really come from a range of 15 down to 4, which we really welcome, it has really shown that you always have to apply to the day that the person died. So if somebody died in 2005, they're still paying the 15. All of us sitting in here today, we're looking at 4%.
What about money owed? How do the beneficiaries deal with this?
Contract debts. Your debit cards, your credit cards, whatever you may owe, they will allow me to deduct that. You remember we're paying the tax on your real estate. So they will allow us to deduct your mortgage, because you know that was the downside of owning your asset. Here's the catch. If you borrowed the money from any building society or any life insurance company, what would have they insisted on? Life insurance being in place. So if the life insurance is in place, and what really happens is the liability is being liquidated, yes, after you have died. So we can't turn around and in your estate now when we're going to apply for your grant of probate or your LA, we cannot deduct the mortgage. So you take all of your liabilities, subtract that from your assets, and then we're going to apply the tax to it. Remember, you're going to have the interest of the 6% if you have not wrapped up your estate in under the 12 months, which is possible if you've gone to an attorney who knows what they're doing and the estate has no complications. The second tax, because all of that was just the first one. The stamp duty. Again, you remember Georgette talked about it. Once you have any dealings with any attorney, what they always tell you, the document has to be stamped for it to be binding in the court system. So the same principle obtains when we die. All of your documents that Georgette took you through for your application for your grant of probate or your application for your grant of administration have to be stamped.
Then there's stamp duty as well as attorney's fee. These have to be paid.
So the government says, well, okay, what are we going to come up with? They came up with not that 15, which came down to 4. They are hitting you under our Stamp Duty Act at 3%. It's not now 3% of identifiable assets that they chose. It's 3% of everything that you own. So what am I going to bring back in? The real estate that you own in Jamaica and overseas. I'm bringing in your stocks and shares that Mayberry is investing for you. I'm bringing back in your stocks and shares that you have in your own private companies. I'm going to go on. Your debentures, your household contents, your money in the bank account which is in your name alone, all of your jewelry, your motor vehicles, everything that you own, we have to be paying 3% stamp duty on it. Now when you hear me saying 3%, it's actually a graduated scale. That's going from 1% up to 3%. So I'm really giving you the cap of the tax itself. And they applied the same principle, net market value. What's the value of all the assets when you died? Take away your liabilities that we can prove, and then we will apply the 3% tax. Attorney's fees, Georgette, this is the one I always remember. You forgot the 15, you forgot the 3% stamp duty, but you always remember what the attorney is charging you. This unfortunately went through some changes as well. Before, estates take 12 months, as I mentioned, if you're applying for a grant of probate. You couldn't afford attorneys at an hourly rate because the estates just take too long. If you have no will, it's going to take us 2 to 4 years to do your estate. So lawyers can't charge you on an hourly basis. So the Bar Association at the time set the legal fees for attorneys. And they said any estate that was under $250,000, we were allowed to charge you 5%. Any estate that was over 250,000, which is really what the majority of their estates, we were allowed to charge you 3%. They then said it's illegal for all of us to do that. We can't fix fees anymore. They want the market to determine what we're going to pay. So that 5% that lawyers never got, what do you think happened? We now are charging you that 5% to get your grant of probate or your grant of letters of administration. And to transfer your real estate and your shares, we're charging you an additional 2%. So lawyers' fees are ranging between 5% up to 7%. But we were not kind and didn't do the net. We're going to charge you on the gross value of all of your assets when you die.
Estate planning is vital, and next week we'll look at what happens when it's not properly done and the subsequent breakups and violent quarrels in families which occur.